Shano Farnan is with us. He is a producer of this program. He's also a law school graduate and the Supreme Court reporter for the Talk Radio News Service. And Shano, welcome.
How you doing, Tom?
It's weird to say welcome when you're in the
when I've been here for 2 hours already.
Yeah, you sit here every day. But anyhow, welcome to On the Air with me. And you were at the Supreme Court this morning.
Yes. The Supreme Court has a lot of work to do in the next 2 weeks because their term ends next week. And they had, before this morning, had 19 cases to get to. Mm-hmm. They got through 5 of them today, leaving 14 for, they have this Thursday and next Monday right now on the schedule. They'll probably add a few more days, but 5 big cases today. Well, 2 big cases and 3 less big cases, unless you're a litigant in those.
Mm-hmm. So let's go through them.
Sure.
The one that gets a lot of headlines is they knocked down Arizona's voter suppression law. Yeah,
back in 2004, Arizona had a Proposition 200 that passed. That was there to combat voter fraud that's pretty much non-existent, requiring voters to present proof of citizenship when they register. Right. So instead of just swearing under oath, which federal law requires, they had to present extra evidence, and if they didn't present this evidence, their registration was getting rejected. The Supreme Court looked at this and said, well, no, there's this federal law, the National Voter Registration Act of 1993, and under that, we have this Election Assistance Commission, and they decide what the form says, and you must use and accept this form, State of Arizona, when registering people to vote.
And by the way, all the form basically says is that you must, in order to demonstrate that you're eligible to vote, you must swear to that. You don't have to show a driver's license.
Nothing.
You don't have to, but you have to swear under oath that you are a citizen of the United States
under penalty of perjury.
Under penalty of perjury, which is in Arizona, what, 5 years in the clink?
I think it's 3. I looked it up. It's interesting that perjury is a much more severe penalty than voter fraud.
Interesting.
So if they're trying to use the criminal law to prevent voter fraud, they actually made it less teeth in the new law.
Right.
But it's actually what they're trying to do with this law is instead of a prosecutor having to prove that you committed voter fraud, you have to prove that you're a citizen. It shifts that burden of proof.
This is how they they didn't knock 33,000 people out the voters' rolls. They prevented 33,000 people from registering in effect from voting.
Right, because in 2006, the Supreme Court kind of said you could do this. Yeah. And then they went back and reviewed it again. Today they struck it down saying that the federal form is enough. And it was interesting that Scalia delivered the opinion of the court in his bench statement. Half of it was dedicated to, well, this is the way the law is. In Arizona, if you really want to do this, here's the steps to take. So he went on to say, Arizona, you can go to the Election Assistance Commission. You can ask them to include this in the form, which they had done before. And the commission had said, no, you can't do this. But they just went through with it anyways. And he said, then after you get that determination, then you go appeal it, and then appeal it, and then we'll take a look at it later, essentially.
Was he saying that in the context, in your opinion, of here's how you can reconfigure your appeal to us so that we will allow you to have voter suppression laws?
Yeah, he's just saying use the correct process. Because under it is right now, this was a really narrow, you have to use this form because the federal law preempted your rule.
Right. So basically, he was just ruling on what the law is as passed by Congress.
Right. Yeah. Exactly. It was a 7-2 decision.
Yeah.
So, pretty wide one. Another case that was really I found a lot of interest in. I know that you were interested in intellectual property, patent law. Mm-hmm. And you may have. I think you talked with Victoria about this when this case was argued. Pharmaceutical companies that have a patent on a drug. Sometimes there's the generics that come out, and they compete. One thing that goes on in this situation is when the generics come out and they say, we're going to compete with you and we don't violate your patent, there's a lawsuit that ensues. And when they're suing each other over this patent, what happens in a lot of cases is that they'll just settle before they reach the merits of the patent, and they collude. Essentially, the person who owns the patent says, I'll pay you tens of millions of dollars over the next, in this case, 9 years, to not compete with me.
Right.
So what happens is you have a market for a drug where there could be competition, the prices could be lowered, but essentially what they do is they just share the monopolistic profits.
Right.
So the FTC brought a lawsuit against, let's see, the FTC versus was Salve Pharmaceuticals, and they were in agreements with activists and a couple other pharmaceutical generic companies. Right. They had this collusion. They were sharing monopolistic profits. The lower courts had said, FTC, you haven't brought forward a true antitrust case because the patent was never litigated. The Supreme Court said, no, FTC, you can go forward with this. So, it was just one step, one hurdle towards prosecuting this. But the Federal Trade Commission can go after pharmaceutical companies that collude this way.
Yeah. So, in other words, the FTC can enforce competition.
Right.
Big government can prevent big corporations from diminishing competition.
Yeah. And the thing is that they just can bring the case. We don't know how it's going to turn out. They just sent it back and said, okay, now let's go into the facts of it in the lower courts, litigate whether or not this is anti-competitive, what the punishments are, et cetera. Right. So another case, Mariach v. Spears. I'm sure I'm mispronouncing that. It's a name that I've never been able to get right. This was a case in which a bunch of trial lawyers in South Carolina asked the DMV for lists of names and addresses and all kinds of information. And South Carolina turned this over to the trial attorneys. And the attorneys wanted to use this information to solicit new clients in a case they were bringing against car dealerships. And these individuals whose personal information had been revealed by the DMV brought a lawsuit saying it violated what's called the Driver Privacy Protection Act of 1994, which generally prohibits states from disclosing personal information. Because when you go to apply for a driver's license, you give the DMV all kinds of information. Sometimes even medical information, seizures, eyesight, your name, address, what cars you're driving, et cetera.
Social security number.
Those things are protected by this federal act. But there are some subsections, some exceptions to this. The trial lawyers said, well, this is exception 4B, that we were getting this information in connection with, this is the legal language, a judicial and administrative proceeding, including investigation, anticipation of litigation. Okay. The court said no. Now, solicitation is a completely different thing. That's a business transaction. You're not acting as a lawyer. Right now, you're acting as a hustler.
You're looking for business.
You're acting as a hustler.
Yeah. These were law firms that were looking for people to engage in a class action suit.
Right, against some car dealerships. Yeah. And they said the DMV, you can't do this. Yeah. Okay. Another one. This is really interesting. His criminal case, Eileen versus United States. A couple guys robbed a store owner together, aided and abetted, and one of the guys had a gun. The guy who didn't have a gun was also convicted, and he was convicted of aiding and abetting and participating in a robbery that involved the use of a gun.
Which is a higher penalty than one that doesn't involve the use of a gun.
Well, actually, using a gun is 5 years. Brandishing a gun is 7. By the way, wait 1 minute. So the jury found that he used a gun, but it was no evidence was put forward about the brandishing of the gun, okay, which is 7 as opposed to 5. The judge, after he had been convicted by the jury when sentencing, went on to hear evidence and decided that, yes, his cohort did brandish this gun, therefore he gets 7 years.
Right.
Supreme Court said this violates the Sixth Amendment because if it increases the amount of time, that brandishing is an element of the crime and it has to be proven beyond a reasonable doubt before the jury. The judge can't just decide it.
Right. The Sixth Amendment is you have a right to a jury.
Right to a jury trial of your peers.
Speedy trial.
And all criminal proceedings.
Yeah, no, wait a minute. 7th is speedy trial, isn't it?
7th is civil trial.
Okay.
7th is you over $50, you're entitled to a jury trial for civil matters. So, but yeah. And there's one more case, but we're not going to have a chance to get to it. It had to do with
6 shell casings.
Oh, yeah. This had to do with whether or not if you were silent, if that is admissible against you.
Oh, yeah. This guy was asked, basically, is this your gun? Were these your bullets?
Yeah.
He didn't answer, and they used it against him. And the court said you can do that. Mm-hmm. He should have said, I ain't talking, I'm invoking my Miranda rights.
Exactly.
Amazing. Shane Farnan, thank you.
Thank you.